Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. It appears that there may be an agreement of sorts regarding one of the issues that has been debated between the parties in the Limine filings, and this has to do with the defendant's alternative perpetrator evidence and theory. Please look at the state's reply to defendant's objections to state's motion in limine regarding alternative perpetrator evidence. This is dated March 21st, 2025. It was just released yesterday, the 24th of March. And basically what the state was seeking in this in limine motion was to, in my opinion, try to keep out junk evidence by not having wild theories or presumptions come into the case without satisfying the rules of evidence. The defense came back and said that it had not just one, but many alternative perpetrators and evidence thereof, and that the defense intended to comply with all of the rules of evidence. And so here we see the state coming back. Let's read what they have to say here. Although the defendant purports to, quote, object to the state's motion and ask the court to, quote, deny the same, in truth, the defendant appears to substantially concur with the legal standards articulated by the state in support of the instant motion. And again, citing to State versus Meister, which is the Idaho Supreme Court case 2009, which has been cited before in these briefings on this particular in limine motion. This goes on to say the defendant acknowledges that he must make a satisfactory offer of, going on to page 2, proof prior to offering or arguing an alternative perpetrator theory. Consequently, the court should grant the state's motion and enter an order prohibiting the defendant from offering, quote, alternative perpetrator evidence or argument without first satisfying the court that such evidence is relevant and admissible, and citing to the Idaho Rules of Evidence 401, 402, and 403, as well as this Meister case again. And then the state says that under the authority of Meister, which cites approvingly to State versus Self, which is an appellate court ruling out of Idaho from 2003, the defendant's proffer or offer of proof must include evidence specifically connecting persons other than the defendant to the crimes, recognizing, quote, that mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, would still be subject to the limitation provisions of the Rule of Evidence 403, citing to the aforementioned Meister case at 204, which then cited to the Self case. In conclusion here, the state further requests that the court set a reasonable deadline for the defendant to make any proffer offers of proof regarding alternative perpetrator evidence or arguments sufficiently prior to trial so that the issues can be fully reviewed by the court, appropriate admissibility decisions made, and the parties prepare to proceed accordingly. And this is signed by William W. Thompson, Jr., prosecuting attorney. And so we see here, although the state is wanting its motion in limine granted, the concession here appears to be in this last paragraph, setting a reasonable deadline for the defendants to make these proffer offers of proof regarding any alternative perpetrator evidence or argument prior to the rapidly approaching trial date, ladies and gentlemen, which is going to start with voir dire on July 30th. And it appears that no such offer of proof has been made thus far. So I think that this is a reasonable request by the state. That's my opinion that I give. Under the First Amendment to the U.S. Constitution, we shall see what will be argued by both sides at these crucial upcoming hearings on all of the in limine motions, including this motion in limine regarding alternative perpetrators. This will now conclude this episode of the Indie Zone podcast. My name is Kathy. Thank you for joining us here today.